there. Honestly, this presentation should have been titled How to Avoid Probate, because that is the goal. The ultimate goal is to do what is best for your client, what will keep more money in their pockets at the end of the day. And as you will learn, probate is very expensive. So when a client comes into my office and says, I need to file a probate case, this is the mental checklist that I go through every single time to make sure that there's no other avenue available to the client so that we can avoid the expense of the full-blown probate. So first and foremost, for those of you that are not familiar with probate but probably have heard of the word probate, probate is a court-supervised process of gathering a deceased person's assets and distributing them to the creditors and heirs, and obviously paying the attorney and the court costs. Whenever you're dealing with a deceased individual and that deceased individual is on title to a real property, you are in the probate world. So you need to put on your probate thinking cap and think of everything we're going to discuss today. Probate is necessary if a person passes away with or without a will, and that's one of the biggest misconceptions. You in your career probably have already encountered clients or will encounter clients that will tell you, realtor, my mom passed away, I want to sell this property now, my mom had a will, here's the will, I'm listed as the executor. That does not give that potential client the authority to sign your listing agreement at that time. They still have to go through the court process. So remember, whether someone had a will or didn't have a will, you need to go through the probate process. What is a will? A will is a simple 2 to 3 pages, a document that a person creates during their lifetime, and in that will they indicate, when I pass away, I nominate this person to serve as executor of my estate proceeding. I give my assets to the following individuals. And most importantly, you may end up in probate court, but you may not necessarily have a probate transaction. And this is super important because if you have a probate transaction, obviously you have to use the probate purchase agreement. But in some instances, we may go in front of a probate judge, but we're in and out of probate court, and you as a realtor do not have a probate transaction. So that means you don't need to use the probate purchase agreement. You don't need to worry about court confirmation or whether an heir is going to object to the transaction. All you need to worry about is this is a standard sale. It's not a probate sale. So you'll understand why I'm saying this shortly. The reason we want to avoid probate is, one, the fees, and secondly, it takes a long time to finalize the entire probate. You as realtors are in and out of the probate process. You know, you come into the picture, your client signs a listing agreement, you market the property, you accept an offer, you open escrow, you close escrow, and you as a realtor, you get paid at the close of escrow. Me as an attorney, I don't get paid until the entire probate case is finalized. And normally that takes about 1.5 years. Now with COVID-19 and the courts being closed for, I think it was like 100 days, our time frames got completely thrown off schedule. So now to close a probate, it's probably going to take us 2.5 years, 3.5 years, I have no idea. You know, pre-COVID-19, when I would file a probate petition, the hearing would be scheduled about 6 weeks out. Now in LA County, when I file a probate, it's not being scheduled until the end of the year. That means the client isn't going to have the authority to sign your listing agreement or sell that property until the end of the year. There's a probate case I filed like 2 weeks ago. The hearing isn't going to take place until November of 2020. San Bernardino County, they're still scheduling them within 6 to 8 weeks. So if you do have a probate in San Bernardino County, know that it's going to be heard a lot sooner than LA County. So keep that in mind. So that's one of the downfalls. The second downfall with probate is that we as attorneys get paid a statutory fee. Obviously, it's not bad for my pocketbook, but it's bad for the client because we're not looking at market value. No, we are looking at market value. We're not looking at equity. So we as attorneys get paid on what the market value is, what the house sold for, what did it appraise for. We don't care if there's a $200,000 loan on the property mortgage. We're going to get paid on the market value. So to give you an example, if a probate is comprised of one house and that one house is worth $500,000, the attorney will receive at least $13,000, at least. And the reason that I say at least is because we have the ability to ask the court to increase our fees if that probate case was a bit more difficult than our average probate cases. The personal representative, the individual that assists the attorney handling the probate is also entitled to the same amount without even going to law school, passing the bar exam, nothing like that. So 13 plus 13, that's $26,000 just in attorney and personal representative fees. But keep in mind, that's just if there's one house worth $500,000. Obviously, if there are several properties or there's a bank account and a home, the fees go up. These fees do not include the court filing fees, the probate referee fees, any creditor claims that get filed in the proceeding, or any Medi-Cal claims. And this is a huge one because before I am able to close out a probate proceeding, I need to show proof to the judge that I notified Medi-Cal about this probate case. The reason being is we need to afford Medi-Cal an opportunity to file a claim. So if Medi-Cal provided any benefits to the decedent during their lifetime, Medi-Cal can file a claim in the probate proceeding and they will get paid before anyone else. This also includes the franchise tax board. Recently I closed up a probate where the property had a reverse mortgage, so obviously there was not a lot of equity to begin with. Then Medi-Cal filed a claim for about $134,000. So none of the adult children received a dime because all the money went to pay the court costs, my fees, the personal representative fees, and then obviously Medi-Cal. So this is why we want to avoid probate. One being the length of time it takes to close out a probate, and secondly, the attorney fees and costs that are associated with probate. So how do we avoid probate? The first way of avoiding probate is joint tenancy. If two or more individuals own a property as joint tenants, as long as there's one surviving owner on title, this is not a probate case. I'll give you an example. Let's say you go to a listing appointment. The client that you have in front of you tells you, realtor, we want to sell this home. On title, my mom, my dad, and I are all listed on title. There's 3 of us listed on title. The problem is that my parents have passed away. So you automatically think, okay, someone has passed away, they're on title, this is a probate. But the very first thing you need to do is you need to confirm how title was taken. You need to confirm vesting. If vesting is as joint tenants or as joint tenants with the right of survivorship, so long as you have one person that is alive, you are able to proceed with that listing. That is not a probate transaction. You don't have to wait on anything besides obtaining the death certificates of the decedents at some point to be able to record those. The issue that you may encounter is that the person you have in front of you may not have capacity. So if everyone else on title has passed away, but there's one person and that one person doesn't have capacity, then obviously you have an issue because a person needs to have contractual capacity in order to sign your listing agreement and then ultimately accept an offer. Joint tenancy can be held with anyone. They don't necessarily need to be married. They don't necessarily need to be related. It can be between siblings, ex-boyfriend and ex-girlfriend, friends, whatever the case may be. All you need to confirm is that after their name, you know, when you look at a deed, after their names, there has to be vesting, and it needs to be as joint tenants. It can be husband and wife as community property with the right of survivorship. It can just say as joint tenants, or it can say joint tenants with the right of survivorship. The individuals that have passed away, you need to remove them from title. Normally, some escrow companies will prepare those documents to remove those individuals. When I mentioned earlier that the living person needs to have capacity to sell, that's super important. You may encounter a situation where that person has signed a financial power of attorney authorizing someone else to make financial decisions for that person. If that is the case, you need to send that financial power of attorney to your title officer. You need to confirm that the title company is actually going to honor that power of attorney in the sale of the home, because you don't want to waste your time and money marketing that property, accepting an offer, getting it into escrow, just to come to find out that the title company says, hold on, this power of attorney has coffee stains all over, it has scribbles where the signature needs to be. We're not going to honor this power of attorney because it's too much liability for us, the title company, because we're telling the buyer that this seller holds clear and marketable title and that they gave the legal authority to someone else to be able to sell that home. So the title company may be a bit reluctant to honor your power of attorney. So if they're not going to honor the power of attorney, the only way around it would be to initiate a conservatorship, but that can be quite expensive. So how do you remove a joint tenant? You complete the affidavit of death of joint tenant. You attach a certified copy of the death certificate. You also include a preliminary change of ownership and a change in ownership statement of death of real property. These are documents that the assessor's office will want to see. Here, time frame for removal: immediately upon recording. The fees associated with it are the recording fees. Anyone with knowledge can complete the affidavit of death of joint tenant. So it doesn't need to be the surviving owner to sign that affidavit, because if that owner doesn't have capacity, anyone else that has knowledge that those two other individuals on title have passed away can sign that document. All you need to wait for is to obtain the death certificate, which normally takes about 30 days. So you don't necessarily need to remove the deceased individuals from title before listing the property. You can go ahead and list the property, so long as you have done your due diligence and you know that title was actually taken as joint tenants. If you look on the deed and if just lists their names, but it doesn't say as joint tenants, then you cannot use this procedure. The deed literally has to say as joint tenants with the right of survivorship, husband and wife as community property, husband and wife with the right of survivorship. Here is a cutout of the affidavit of death of joint tenant. I would not complete this for your clients. Like I mentioned, escrow can go ahead and prepare it, or they can retain an attorney to prepare this form. The second procedure is a spousal property petition, and this is fairly common, and it's one of my favorite procedures because one, I encounter it fairly often, and secondly, it helps my clients avoid probate. So this is the fact pattern. You go to a listing appointment and the wife tells you, realtor, I want to sell this property. My husband recently passed and he is the only one on title. Obviously, you're in the probate world because someone passed away and they're on title. The problem here is that the majority of the time, the decedent is the only one that was on title. So the decedent owns 100% of that property. This may occur because either the wife wasn't listed on title just because she wasn't on the loan, given that her credit affected the rate that they would have obtained if she was on the loan. So it's fairly common for a property to be bought during marriage and just one of the spouses be on title and they never got around to adding the other spouse. So with this procedure, we can avoid the full-blown probate. So by avoiding the full-blown probate, we avoid the probate statutory attorney fees. So your client isn't going to have to pay a percentage of the value of the home. These are done on a flat fee basis or hourly. But what are the requirements? And they're listed here. The deceased is survived by the spouse. And the reason it's in red, bold, and underlined is that this is the most important element. It's a requirement. You need to ask your client, were you legally married to the decedent? And once they start giving you excuses or giving you a story, then that means they were not married. If they tell you, no, we never got married, but we have 10 kids together and we've been together ever since elementary school, that's not enough for this procedure. They were not legally married. California does not honor common law marriages. That only happens in movies and in other states, not in California. So when you have clients tell you, oh, I know of this rule that once we live together for 10 years, we're considered to be husband and wife. No, they're in the wrong state. California does not honor common law marriages, so they actually have to be married. Secondly, the property is a community asset. What is a community asset? Anything acquired during marriage is presumed to be a community asset. So you're going to ask your client, when did you get married to your husband and wife? When did you buy this home? What money did you use to buy this home? Was it an inheritance that your husband got or that you received? Or was it your earnings from your salary? So as long as the home was bought during marriage and a community asset was used to purchase the home, meaning their salary, you're good to go. However, if that home was bought a month before they got married, this procedure doesn't apply. So literally the home needs to have been bought during marriage. Secondly, if the decedent had an inheritance and he used that money to buy this home, you're not going to be able to use this procedure. There's no will disposing part of the property to another person besides the surviving spouse. Normally, there's not going to be a will because someone died suddenly, so they didn't even have the opportunity to add their spouse on title. And there's no agreement between the parties that affects the disposition of the property, so there's no prenup. With this procedure, the surviving spouse is telling the judge, Your Honor, we live in a community property state. The decedent and I were married 20 years ago. During our marriage, we bought a home, but for whatever reason, my husband was the only one on title. However, 100% of the property goes to me for the following reasons. One, 50% of the property already belongs to me because we live in a community property state. And we bought the home during marriage with our community funds. Secondly, the property goes to me because I am married to my spouse, or I was married, and I am his or her heir at law. So 50 plus 50 equals 100. In this procedure, the judge, if he approves this request, he will sign an order that your client is now the owner of the property. We record that order and the surviving spouse is now the owner of the property. So this is not a probate transaction. We're in and out of probate court. So you're going to market this home as you normally would in any normal transaction. So the client doesn't have to deal with a full-blown probate and with the statutory attorney's fees. This procedure can be used for 100% of the property or whatever interest the decedent had in the property. Let's say that husband owned an investment property with his brother and title was as tenants in common. Remember, not joint tenants, because joint tenants, it automatically goes to the brother. But if husband and brother own the property as tenants in common, the wife can file this petition for 50% of that interest in that home. In other situations where husband and wife are both on title, but there's no vesting, you can also use this procedure. Let's say you look at the deed and it says the grantees are husband and wife. Their names, literally, nothing else. It doesn't say Bob and Jane as husband and wife with the right of survivorship. It doesn't say Bob and Jane as joint tenants. The deed literally says Bob and Jane. So since there's no vesting, the default is tenants in common. So when title is held as tenants in common, you need to probate each individual's interest in that property. So just keep that in mind, because you will encounter situations where deeds are prepared by like notaries, paralegals, and they mess up and there's no vesting. So maybe husband was the only one on title. He went to a notary and said, notary, prepare a deed adding my wife on title. So that's exactly what the notary did. He added wife, but there's no vesting. So then wife is stuck in the situation where she needs to probate 50% of that home, so you would be able to use this procedure. This is the steps how we go about this. First, we file the petition in court. The hearing is set anywhere from 6 weeks to 5 months out. We mail out notices, we attend the hearing. If there's no objections, then the order is granted. We file certified order with the recorder's office, and the surviving spouse is now the listed owner of the property. Time frames, don't really pay attention to the time frames. Like I mentioned, COVID-19 has really thrown everything off schedule. LA County, now it's probably going to be 8 months. With LA County, we have to submit the proposed order electronically, and then the judge has to sign it, and it normally takes about 4 weeks after the hearing to sign it. With San Bernardino and Riverside County, I can actually walk out of the courthouse with a signed order, but with Riverside, they're not really allowing us in the courtroom right now, so that's probably going to affect the process of obtaining a certified order. Orange County, this no longer applies. The 6 weeks doesn't apply. It's probably going to be 3 to 5 months out now. But like I said, the benefit is they're avoiding the statutory attorney fee. Brief summary, like I mentioned, you end up in probate court, but this is not a probate sale. The statutory attorney fee does not apply. Ownership is transferred to the surviving spouse. So far we've discussed 2 procedures. The first one was joint tenancy. Remember, joint tenancy, there's no relationship requirement as long as vesting is held as joint tenants. The individuals on title don't need to be married. They don't need to be related by blood, nothing. All we require with joint tenancy is that vesting is as joint tenants. With the spousal property petition, the most important requirement is that they have to be married. It has to be between spouses or else it will not work, and the property must have been acquired during their marriage. Even if the property was bought a week before they got married, this is not going to work. The next procedure we're going to discuss is real property valued at or under $166,250. I am not crazy for discussing this procedure, and here's why. We're talking about property owned entirely by the decedent, or whatever interest he or she had cannot exceed $166,000 at the time of death. So Most people do not commence the probate proceeding immediately upon the person passing away. Sometimes you're going to encounter situations where you have an adult child. When I say adult, someone in their 50s living in their parents' home, and their parents passed away like 30 years ago, and they never commenced the probate procedure because they had no need to. They were living rent-free, they were paying the property taxes and insurance, and they really didn't need to sell the property. So they get to a point in life where they want to sell the property, or their siblings are telling them, okay, enough is enough. You already lived at that home free for such a long time that we need to initiate the probate process. Give me 1 second. Okay, so then when you go to these listing appointments, you're going to ask your client, when did the decedent pass away? If the decedent passed away 30, 20 years ago, it's possible that the home was worth under $166,000 at the time of death. Secondly, you're going to look at what interest you're going to probate. Sometimes individuals own a property with their siblings as tenants in common, and one of them passes away. So we're only probating a quarter of the home, 50% of the home, 3/4 of the home, whatever the case may be. You also will encounter this situation when paralegals mess up the deeds. I had a situation where my client, the seller, thought that she owned the property as joint tenants with her dad, and that wasn't the case. She got a big surprise when she was trying to close escrow. So on that property, the dad originally was on the deed. The dad went to a paralegal and said, I want to add my daughter to the title of this property, so both of us are on title. So obviously the paralegal prepared the deed, but they just forgot to add one important detail, that it was supposed to be as joint tenants. So the deed literally read dad and daughter. Obviously it had their names, but there was no vesting. So she was under the impression that it was as joint tenants. Once title looked at it, they said, no, there's no vesting. It's as tenants in common. Your dad has passed away. We need to probate his interest. Luckily, the dad's 50% interest in the property at the time of his passing, which was like 5 years prior to that, was worth $166,000 or less. So if that's the case, we go in and out of probate court. First and foremost, we have the probate referee appraise the property. Once we get that back, it normally takes about 4 to 6 weeks to complete, and we have to wait at least 40 days from the date of passing. We can file the petition. In that petition, the heir at law can file this petition. So if someone wasn't married, but they had kids, the children would be the one filing this petition. If someone wasn't married, didn't have kids, and their parents were not alive, then it's the siblings that would file this petition. So with this petition, it is the heirs at law if there's no will, the next ones in line to receive the property. For the court date, disregard this because we have no idea what it's going to be. We send out notices, we attend the hearing, we obtain a signed certified copy of the order, we record the certified order, and the heir at law is the new listed owner. This is not a probate sale. The heir at law is now the owner. So remember, with this one, the heir at law is the one that's going to file the petition. It could be the daughter, it could be a sibling, whoever it is. So far we discussed 3: joint tenancy, the spousal property petition, and then property valued at or under $166,000. Next, we're going to discuss living trust. With living trust, a property owned by a decedent's living trust does not have to go through probate. But let me backtrack a little bit. What is a living trust? A living trust is an agreement that a single person or a married couple creates during their lifetime. In this agreement, that individual or that couple, list their children, their assets, how their assets are going to be distributed upon the passing of one of them, and who's in charge of managing the trust. That person is called the successor trustee. So let's say you go to a listing appointment and your client tells you, realtor, I need to sell this home. My parents passed away, but don't worry. My parents had a trust. They weren't dumb. They wanted us to avoid probate. So we have a trust. They hand you the trust. You look at the trust. Well, you glance at it. And sure enough, the person that you have in front of you is listed as the successor trustee. The home that you're trying to sell is listed in the trust. So you think to yourself, great, I'm ready to go. No. You need to confirm that title reflects the name of the trust. It is not enough for someone to have a trust and for the trust to list the subject property. When you look on title, the last recorded deed needs to reflect the name of the trust. If you look at the last recorded deed and it just lists Bob and Jane, husband and wife, that's not enough. It needs to list Bob and Jane as trustees of the Bob and Jane Trust created in 2000. That's what it needs to say. If title does not reflect the name of the trust, you will end up in probate court, but it may be a very quick procedure. And this is what we call a EGGSTAD petition. If the EGGSTAD petition is not granted, then you will have to do the full-blown probate. So what is the EGGSTAD petition? The objective of the EGGSTAD petition is to have the judge transfer the property back into the trust so that you can proceed with the sale and avoid the full-blown probate. So the fact pattern is the decedent had a living trust, but title does not reflect the name of the living trust. So we just discussed that. We go in front of a judge, we tell the judge the decedent had a trust, it was his or her intent for his or her property to be part of the trust, but for whatever reason, title was never formally transferred into the name of the trust. If the judge thinks that there was enough evidence presented to him or her, they will approve the request. Be very careful. If title at one point was in the name of the trust, but it was taken out for whatever reason, a reverse mortgage, a refinance, or whatever the case may be, if it was taken out of the name of the trust and it was never put back into the trust, the judge will deny the request. The judge will think to himself, if the individuals wanted this to be part of the trust, they would have transferred it back into the trust. We all know it doesn't happen like that. Someone's going to go and refinance. The lender may take it out of the trust, and husband and wife will not think to call their attorney or think that anything happened, that they need to do something. So just be very cautious. Look at the chain of title. If title was ever in the name of the trust, the judge will not grant this petition and you will have to do a full-blown probate. What are you going to look for? Most trusts should have a schedule of assets. At the very end, it should have a schedule that indicates these are community assets or these are the trust assets. If the property you're trying to sell is listed on the schedule of assets, that's a slam dunk case. So long as title was never in the name of the trust, the decedent simply forgot to transfer title of his or her property into the name of the trust. So that's a slam dunk case. If there's a general assignment, if there's any language in the trust that indicates that the grantor, the person that created the trust, intended for all of his or her real property to be owned by the trust, regardless if title reflects that, the judge will grant it. If there's a specific distribution If the trust specifically references a property that you're trying to sell, then the judge will grant it. So if within the trust it says my property located on Green Street goes to my daughter, and that's the property that you're trying to sell, the judge will grant it. You find a signed, unrecorded copy of the deed. This is very important because if you find the original deed whereby the decedent signed to transfer ownership into the trust, you can go ahead and record that. You will not believe how many cases I've prevented from being filed when I tell my clients, go and look for that original deed. If you believe your mom and dad signed the deed transferring ownership into their trust and they just forgot to record it, go look for it. And then go and record it, and now title's in the name of the trust. However, obviously, you cannot record a copy of the document. It has to be the original. So if you find a copy and you are not able to find the original, this would be good proof to show to the judge that it was the intent of husband and wife to transfer it into the name of the trust. This is the procedure. We file the EGGSTAD petition with all the supporting documents, the trust, the will, and so forth. The hearing is set 2 to 4 months out. We serve all the heirs at law and all the beneficiaries listed in the trust. We attend the hearing. If the petition is granted, the judge will sign the order and transfer title into the name of the trust. We record the certified order. Now the owner of the property is the trust, so the successor trustees can proceed with the sale of the property. Tips for handling trust sales. Make sure to have the trustee obtain an appraisal before listing. I know that you as realtors will prepare your comps, but sometimes there's a lot of distrust between the heirs and the trustee, that if they believe that the trustee undersold the property, there will be problems, namely litigation. So it's best to have an appraisal. In my office, before we close escrow, we send notice to all the beneficiaries. So if they want to object, speak now or forever hold your peace. Also have your client consult with an attorney. They don't necessarily need to retain an attorney, but they should seek the advice of an attorney, because with the trust administration, there are certain statutory notices that need to be sent out. And there are assessor forms that need to be completed within a certain time frame. The statutory notice that I'm referring to is that the beneficiaries are entitled to a specific notice indicating who the successor trustee is, advising the beneficiaries that they have the right to request a copy of the trust, that they have 120 days to contest the trust, and so forth. In regards to the assessor forms, what I'm referring to is the parent-child exclusion. Prior to the trustee selling the home to a third party, the parent-child exclusion form must be submitted to the assessor's office so that the property taxes remain the same. A lot of people believe that since they're selling a home in the name of the trust, that the property will not be reassessed for property tax purposes, and that's not the case. So we all know that if a property is transferred from parent to child, there's an exemption in that the property will not be reassessed for property tax purposes. However, it's not automatic. A request has to be submitted to the assessor's office. A lot of people forget to complete this form when they're selling the property in the name of the trust. This form needs to be submitted to the assessor's office within 3 years of the parent's passing, or prior to it being sold to a third party, whichever occurs first. So let me give you an example. Mom and dad passed away in 2018. Your client, the trustee, was living in the house rent-free, so he really didn't have an incentive to sell the home. Then finally, he got tired of his siblings nagging him that he needed to administer the trust and proceed with the sale. So then in 2020, the client hired you to list the property for sale, but then COVID happened. So that house didn't end up closing until, let's say, 2021. It's not even 2021, but for argument's sake, let's say the house finally closed escrow in 2021, but that was until December of 2021. During that time, from 2018 all the way up till the end of 2021, the parents were gone. They had passed away. A dead person cannot own real property. So at that time, the true owners of the trust were the beneficiaries of the trust, which were the children. But the trustee never completed the parent-child exclusion. So what's going to happen is once the assessor's office finds out that the trust sold the property in 2021 and the parents passed away in 2018, they're going to send a supplemental tax bill listing a reassessment from 2018 all the way up to 2021, because they're going to say during this time the children were the true owners of the property. No parent-child exclusion form was ever submitted. The time frame to do so has expired because now this property has been sold to a third party. And then that's when the client's going to come to you and say, realtor, why didn't you ever tell me that I had to submit this parent-child exclusion form? Obviously, it's not your responsibility to do so, but obviously they're always going to blame you. All right, so now let's discuss the full-blown probate, what everyone came to hear. So if none of the above procedures work, then you will have to go through probate. Someone needs to be appointed as a personal representative in order to marshal the assets, sell the assets, pay off creditors, and transfer property or the proceeds from the sale to the heirs at law or the beneficiaries. Step number 1, we have to file the probate petition. Someone needs to file the petition to get appointed as the personal representative and have the will admitted into probate if there is a will. Like I mentioned before, if there is a will or there isn't a will, you still have to initiate the probate process. If there is a will, your client will be given the title of executor. If there's no will, you'll be given the title of administrator. If there is a will, the person named as executor in the will has the right to get appointed as a personal representative. Obviously, that person isn't forced to act. They can actually decline and say, no, I don't want to serve as the executor. I'm too busy. I have other things going on in my life that I don't want to waste time on the probate. If there's no will, then this probate code section lists the priority of those individuals that have that will get appointed. So first and foremost, it is a surviving spouse. This becomes an issue when there's a blended family because you have the adult children from the previous relationship and the surviving spouse competing to get appointed. So that becomes an issue. So once we file the petition, when we file the petition, we get a hearing date assigned. So in between the filing of the petition and the hearing date, we send out notices. We send out the notice of petition to administrative estate. It needs to be mailed to all the individuals entitled to notice 15 days prior to the hearing. We also publish it in the newspaper. A few weeks before the hearing, we check the probate notes. These are the notes that the court issues after they review the file. If they see any issues with the petition or they're requesting additional information to be submitted, this is where it's going to be listed. We normally try to clear up all the issues prior to the hearing so that the client can get appointed. Then we show up to the hearing. If no one objects and everything was done properly, then the client, the petitioner, will get appointed as a personal representative. If you don't want to get these titles confused, just use the word personal representative. This encompasses executor and administrator. At that hearing, the judge will determine if the petitioner has full authority or limited authority. This impacts you as a realtor, whether you're the listing agent or the buyer's agent, because obviously if you're the buyer's agent, you don't want to have your client stuck in a situation where the seller has limited authority. At that hearing, the judge will also determine if the petitioner has to post bond or no bond is required. What is bond? Bond is an insurance that is obtained so that the personal representative doesn't run off with the assets, because remember, whoever the court appoints, they have full authority to cash the check received from escrow and take off to Europe, and we never see them again. So the courts want to protect the inheritance for all the beneficiaries and also the creditors. The probate order is signed by the judge. The order just reflects what transpired at court. Again, the personal representative is given the title of executor or administrator. It indicates whether bond will be required. In LA County and Orange County, we have to submit the order, and then it's signed electronically, and then we receive it via email. For San Bernardino and Riverside County, it's signed the day of the hearing. However, the order is not the document that you're looking at to see if your client can act. It's actually the letters of administration. However, here's a cutout of the order for probate. Paragraph 3, you would have your client's name listed there. It would list whether your client is the executor or the administrator, whether they have full or limited authority, and whether bond is required. But the letters of administration is actually the document that gives your client the authority to act. Your client's authority does not vest until the letters have been issued. If bond is required, the letters will not be issued until bond is posted. If bond isn't required, then in San Bernardino County and Riverside County, the letters will be issued the day of the hearing. This is a cutout of the letters. So in this paragraph over here, it will list your client's name. Paragraph number 3, whether they have full or limited authority. Okay, selling the property. This is where it gets interesting. One of the main differences between a standard listing agreement and one dealing with probate is the term of the listing. When you take a probate listing, you're still going to use your standard card form RLA if it's a residential property. The only difference is that the listing term can only be for 90 days. You cannot indicate that your listing agreement is for a year, 2 years, whatever the case may be. It can only be for 90 days. The California Probate Code supersedes your listing agreement. So if you have a listing agreement for 1 year, it's invalid. It's only going to be valid for 90 days. It can be renewed for additional terms, each not to exceed 90 days. So a lot of individuals that have their clients sign the listing agreement prior to them getting appointed, they may end up losing out on that listing if they don't work on the relationship with the client. Why? Let's say you have someone sign your listing agreement prior to them getting appointed. My first argument will be that your listing agreement is invalid because when the client signed it, they didn't have the authority to sign your listing agreement. The letters hadn't been issued. The court didn't give them the authority to act on behalf of the estate. So my first argument is your listing agreement is invalid. If we assume that your listing agreement is valid, my second argument would be that now you have an invalid listing agreement because it has exceeded the amount of time allowed by the probate code. So keep that in mind when you're working on your relationships with your clients. You do have to add the probate listing addendum and advisory. Since the client is signing on behalf of the estate, you do need to include the representative capacity signature disclosure form. Keep an eye out in LA County. If the client has limited authority, the commission is capped at 5%. When you're filling out the listing agreement, the seller is the estate of the decedent. The seller is not your client. Your seller is signing on behalf of the estate. So make sure wherever it says seller, it's the estate of Billy Jones. You mark this box indicating that's being sold, part of the probate. The 90 days obviously goes up here where the listing period is listed. I put it down here so you can see it. This is the representative capacity signature disclosure form. This is a form that indicates that your client is signing on behalf of the estate. Again, the seller is the estate of Billy Jones. You're going to mark this box that it's part of an estate. When your client signs, they're literally going to sign their name. They're not going to sign the estate of Billy Jones. You know, if I'm the personal representative where it says signature, you're going to see my signature. Then underneath that, you're going to see my name printed and then my title listed there. Selling the property. Okay, everyone that took a break and is watching Netflix, come back. We're going to discuss what is the difference between selling a property when your client has full authority and limited authority. So you need to be familiar with this process. On the left side, if your client has full authority, remember your listing agreement is the standard residential listing agreement, but you have all those addendums, the probate advisory, the ones that I had on the other slide. You're going to list this property for sale and you're going to market it like you would have in any other normal transaction. You're going to receive offers and you're going to present them to your client, but make sure that all the offers are on the probate purchase agreement. A lot of realtors ask me, well, Georgina, if we have full authority, does the offer need to be on the probate purchase agreement? Absolutely. So whether it's full authority or limited authority, the offer needs to be on the probate purchase agreement. So you're going to receive those offers. You're going to present your offers like you would have in any normal transaction. You're either going to issue counter offers or accept an offer. In parentheses, I put you can accept an offer for any amount. I don't mean to undersell the property. No, you need to accept the best offer. Ideally the highest offer, but you know, sometimes the best offer isn't necessarily the highest offer. So you need to accept the best offer. You open up escrow. The EMD can be any amount that you normally use. There's no requirement. The buyer conducts their inspections. Once the buyer conducts their inspections and the buyer removes their contingencies and the terms of the sale are certain because no one's negotiating anymore for requests for repairs, then I as an attorney send the notice of proposed action. The notice of proposed action is a standard 2-page court form. On that document, I inform the beneficiaries or the heirs at law. We are in escrow. We are set to close in 15 days. These are the sale terms. We're selling the house for X amount of money. We're paying for the termite. We're paying for the home warranty. Whatever the terms of the sale may be, I include them on that form. I also include a copy of the probate purchase agreement and any counters, addendums, whatever the case may be. The beneficiary or heir has 15 days from the date of mailing to do one of 3 things. 1, they can do nothing. They'll just receive the document, read it, say, oh, that's great. If the beneficiary or heir does nothing, that is treated as if they consented to the transaction. Secondly, they can object to the sale. They can sign off on the section of the form that they say that they object to the sale. They'll send that objection to the attorney. Lastly, they can consent to the sale terms. They'll fill out the portion of the document that indicates that they're consenting to the sale and they'll send it back to the attorney. Assuming the heirs and the beneficiaries either did nothing or consented, we can proceed to close escrow. Obviously, if an heir or beneficiary objected, we would have to follow this procedure on the right-hand side. In my cases, when a beneficiary objects, I reach out to them and I ask them, why in the world are you objecting to the sale? Oh, because I think the amount that you're selling it for is too low. I would be happy if we sold it for $2,000 more. And then at that point, I ask them, are you out of your mind? Are you being serious? That $2,000 that you're complaining about, you're not even going to see it because there's like 10 errors in this case. So you divide 2,000 by 10, it's not a lot. What is that, $200? And then if you object, we have to follow this procedure, which is costly and time consuming. So by the time we go through this procedure, we're going to lose out on this buyer. So I've had cases where the heir will withdraw their objection once I knock some sense into them. So assuming no one objected or they all consented, you can close escrow. Escrow will require the following. They will require a certified copy of the letters of administration because the title company needs to record those. They will also require a copy of the notice of proposed action that was mailed out. Then they will want all the consent forms that were signed, if any. Then lastly, a letter from the attorney certifying that no one has objected to the sale. Normally, escrow cannot close in under 15 days because you need to send out the notice of proposed action 15 days prior to the close of escrow. However, if there are not a lot of heirs and they're all talking, then they can sign waivers. And if they sign a waiver of the notice of proposed action, hey, we can close in 7 days, whatever the case may be, 10 days. So this is a procedure if someone has full authority. If someone has full authority, that's when you see on the MLS, no court confirmation required or client has full authority. For full authority, your escrow period is going to be the same as any normal transaction. So if you're representing a buyer and they want to submit an offer in a transaction where the seller has full authority, don't be scared. It's going to be like any normal transaction. Like I said, the only difference is you have to send a notice of proposed action to all the heirs or beneficiaries, informing them of the sale. And if someone objects, then that's going to create a problem. But other than that, it should be fine. If someone has limited authority, that's where it becomes a little bit more difficult. First and foremost, and every attorney handles this differently. I don't like wasting time. Everything I do is very methodical. So with limited authority, first and foremost, I have the probate referee appraise the property. Why? We need to accept an offer within a certain amount of the appraised value. So in my eyes, it makes absolutely no sense to waste time and money marketing a property just to find out that whatever offer we accepted isn't going to be approved by the court. So first and foremost, the probate referee needs to appraise the property. That takes anywhere from 4 to 6 weeks. Once the referee appraises a property, then we publish the sale in the newspaper. Then we list the property for sale and you market it. Let me backtrack a little bit. I always get questions, well, Georgina, what type of appraisal does the probate referee do? They do a desktop appraisal. They indicate that they drive to the property. I don't know if that's true or not. I doubt it, but they say they do. So in cases where the condition of the home is not visible from the exterior, and there's certain aspects of the home that would affect the value, I tell you, the realtor and the client, give me a list and pictures, and I send it off to the probate referee so that they can take it into consideration when they're appraising the property, when they're doing their desktop appraisal. So we publish it in the newspaper, we list the property for sale, and we market it. The counter offer or whatever offer we accept has to be within 90% of the appraised value. We opened up escrow. The EMD needs to be the amount that was published in the newspaper. Buyer conducts their inspections. Once the buyer has conducted their inspections, then we file a petition with the court to approve the sale. This hearing date can be set anywhere from 4 to 8 weeks out, even more now with COVID. So it's going to take a while. We attend the hearing. At the hearing, investors are given an opportunity to submit a higher bid than that was accepted. Then the judge is going to sell it to the highest bidder. So your buyer may waste all this time and money just to come to find out that they're not going to walk away with a property because someone showed up to submit a higher bid. There's a formula to calculate what the bid needs to be at. It's just not going to be $100 more than the one that was previously accepted. Then you close escrow. In this situation, on the right side, escrow will require the certified copy of the letters and a certified copy of the court order authorizing the sale. So if you're representing a buyer, you do not want to get them stuck in this situation where the client has limited authority. The probate purchase agreement, I highlighted this portion here because it clearly indicates that if court confirmation is required, escrow will close within 10 days of escrow receiving the certified copy from the court. I highlighted this. This is paragraph 4. I don't know what page. I'm assuming page 2. But this is important because if you're representing a buyer and the seller had full authority, so you're assuming that everything's gonna go pretty smoothly, but then someone objects, although the buyer has removed all of their contingencies, they have 3 days to object. They have 3 days to cancel the transaction, and then they're entitled to the release of their EMD. So let me say that again. If the buyer has removed all of their contingencies and then someone objects to the sale and you need to proceed with court confirmation, the buyer can cancel the transaction. So this I mentioned earlier, documents required for the close of escrow. I mentioned this already, so let's go on. And I think that's it. My office to set up a consultation, it's $80. You can book it online or call the office to schedule it. So now I will be taking some questions. So you can submit it either in the Q&A or the chat. Okay. One of the questions, when the administrator has full authority with bond, do you need to go to court when you get an offer? No. If the client has full authority, we're dealing with the left side of this chart, so you do not need to go to court unless someone objects to the sale. Okay, my phone number. Oh, there we go. There's a phone number and then my website. Someone had emailed in a question. Let me look at that email. So the email was asking about filling out the probate petition when there is a will, where it says petition 4 as to what should be marked off. It should be for, let me pull up the form on my phone so I can tell you what box needs to be filled out. But if this is a realtor completing the probate petition for the client, I do not advise that because you're going to have issues and the client is not going to be happy. So if there is a will, you're going to mark the box, the first box that says probate of will and for letters testamentary, and then you're going to mark the box authorization to administer under the Independent Administration of Estates Act. So just make sure that if you're a realtor and not an attorney, that you shouldn't be completing the probate petition for your clients. Richard, will switching to joint tenancy affect property taxes? I don't give tax advice, but from what I understand, if you add someone else on title, I don't think your property taxes go up, but call the assessor's office. Don't quote me on that because I do not give tax advice. Copy of this presentation, you need to ask the board.
Well, we're recording this. We're recording this so they can have access to it through that.
Perfect. How does Medi-Cal affect your transaction? Medi-Cal does not affect your transaction. The Medi-Cal claims will be taken care of at the end of the probate. When the sale, when escrow closes, those proceeds are deposited into the estate account, and the personal representative cannot distribute those monies until they have a court order authorizing them to do so. Going back to the chat, once you get letters of administration, how soon can you sell the property? Immediately thereafter, within 15 days, because once the letters have been issued, the client has the authority to sign your listing agreement, has the authority to accept an offer. So legally, you know, you can accept an offer right away. As far as closing the escrow, you just need to follow the formalities of sending out the notice of proposed action. What, okay. Handout of the slides. Yes, I'll send out the slides to your board so they can have them. For a living will, if the property is stipulated to be left to the heirs, does the title need to reflect the trust? So you're confusing two different documents there. You have will and trust. So if there is a trust, title needs to reflect the name of the trust. And normally if someone has a trust, they will have a pour-over will transferring all their assets into the name of the trust. Someone says, I'm single and I own a house. Do I need a living trust? Absolutely. As long as you have a house, even though it's not fully paid for, you need a trust. Why? If you pass away, your successor trustee will be able to contact the lender and obtain whatever information they need to continue making the payments. But if you don't have a trust, the lender will not speak with anyone unless they see a court order. Who can file a trust? Can you do it on my own? I prepare a living trust. I would definitely not recommend someone that's not an attorney to prepare a trust. Nancy, will it be matter if the granted is joint tenant and the trust is community property? So no, if you're doing a trust, the title will reflect the name of the trust. It's not going to have joint tenancy anymore. It is best to own something as a community asset, and that will be reflected in the trust. All right, hold on. Can I put properties in different states under the same living trust? Absolutely. We retain the attorneys and those out-of-state, where your out-of-state properties are located, to prepare the deeds. My parents bought a house. They have agreed to sell the house once one of them passes away. Do they both need a living trust? So it seems like your parents have agreed to sell the home and distribute the monies once one of them has passed away. If they want that agreement to be honored, yes, they need a living trust. If they're just going to say, okay, one of us passes away, the other one's going to sell the property and keep all the money, then I don't really think you need a trust. But if that person lacks capacity, then you would need a trust. Magda, thank you for the compliments. I appreciate it. Now to the Q&A. So for creating a trust, I have a flat fee for single and a married couple. For a single person, the fee is $1,649, and what that includes is the living trust agreement, which is about 80 pages, a pour-over will, a financial power of attorney, an advanced healthcare directive, personal property documents, the deed transferring ownership of that one house to your trust, and the notary fees. Any additional properties are charged at $250. So those were the questions for the trust. Yes, 4 people asked for the fees for the trust. And then for a married couple, it's $2,499. So for a single person, $1,649. Married couple, $2,499. But when you look at the probate fees and the fees to set up a trust, it's obvious it's a lot cheaper to do a trust. Trusts are not recorded. The only document that gets recorded is the deed transferring ownership from your individual name to the name of the trust. So before, like maybe 25 years ago, some attorneys would record the trust, but we don't do that anymore. You know, it's a private document. Once you record something, it becomes a public record. What other questions do you have? Trust versus LLC, what is the difference? They're two different things. A trust helps you plan for the future as how you're gonna leave your assets once you pass away. An LLC is just a way of holding title. If you have a trust, you need to assign your interest in that LLC into the name of the trust. So you need to have both, because if you have an LLC, if you pass away, who's going to receive your assets in your LLC? You need to assign your interest into the trust. So what's the charge for recording and reviewing the trust? So I do not record trust. I only record the deed transferring ownership into the name of trust. My consultation for an hour is $80. During that time, I'll quickly glance through your trust, but if you require me to read the entire trust, then that would be charged per hour. The cost to make changes in the future, that was done hourly. Someone asked, I am married, may I have my own trust? Yes, you can, but that does not mean your wife does not have an interest to the assets that you have in your trust. If you create a trust during your marriage, your wife needs to consent to that. And if she does not and you pass away, she can file an action in probate court to contest it. My client has no trust, no will, and she is currently in long-term care. She is paralyzed and can't make decisions. She needs to sell her house. Her brother is in Europe. Can he set up a conservatorship? Normally, the person that files for conservatorship needs to be in the United States, specifically the state where the person is, because how are they going to take care of that person if they don't live here? Do I need to prepare a new trust if I buy another property or have another child? You need to amend your trust if your distributions are going to change. So for example, if you have another child and that child is not provided for in your trust, then you do need to create another trust. If you buy another property, you can just transfer it into the name of the trust. But if there are specific instructions you want to pertain to that house, you need to amend your trust. If you took the property out of the trust to refinance, how do you get it back into the trust with another grant deed? My office can help you prepare that deed. If a property is held in an LLC and both parents and children are added to the LLC, is a living trust needed? I don't know what you mean by added to the LLC. They're all owners of the LLC. I can't answer that because the LLC operating agreement controls, so I don't know what the agreement lists. Can I make changes to my current trust without an attorney? I would not recommend that because you may make a change that will not be effective down the road because you did not follow the proper formalities. Since the last appraisal was done a year ago by the referee, do we need to do a new one before we put the house for sale? Only if your client has limited authority will you need to do another appraisal. If the client has full authority, you do not need to have the property appraised again. Any other questions?
That's a lot of questions.
Yes, it was a lot.
Well, we have your next class we have scheduled is September 17th. And that one is going to be estate planning.
17th, yes, I have it on my calendar. So yes, that one is estate planning. So we're going to discuss the benefits of having a living trust, and just a great overview of living trust.
Great. We had 52 people on. That's pretty good.
Yes. Can the current live person, the trustee of his own trust? I don't understand the question, Richard, if you want to resubmit it. Can the person be his own trustee? Absolutely. When you create a trust during your lifetime, you are the current trustee of your trust because you're the one in charge. Upon your passing, you either list your children as the successor trustee or another adult to follow your wishes and distribute the money. No, if it's an irrevocable trust, then someone else needs to be the trustee. Anonymous attendee, thank you for the compliment. You're welcome, Richard. Is there a way to pass property to grandchildren instead of children? Absolutely. You can do whatever you want with your property, but if your children are still alive and you transfer it to your grandchildren, the property will get reassessed for property tax purposes. There is a grandparent-grandchild exclusion. However, in order for the property not to be reassessed when you transfer it to your grandchildren, your children need to have predeceased you. So if you skip a generation, the property will be reassessed, but there is no requirement that your children need to inherit your assets. You can leave everything to charity, to a church, to your grandchildren. Why choose irrevocable versus revocable? Some people will create irrevocable trusts for asset protection. Others would do it years ago to avoid Medi-Cal liens because Medi-Cal would also go after trust. But as of January 1st, 2017, Medi-Cal has indicated that if your assets are held in the name of the trust, they will not seek to recover. I don't handle conservatorships, so sorry, I wish I could help, but no, you would need to contact an attorney that does handle conservatorships. But thank you for thinking of me. Yes, I am bilingual. I speak Spanish. I already have a trust but not recording yet. I believe you mean that the deeds have not been recorded. We can help you with the recording of the deeds. Richard, does the Medi-Cal rule cover both types of trust? Everything. If you're avoiding probate, Medi-Cal will not seek to recover. So people that created irrevocable trust prior to 2017 now are regretting it because they cannot make any changes to that trust unless all the beneficiaries consent. Thank you for the compliment again. All right. I think I answered all the questions already on the Q&A and on the chat. Anything else then before we end? And just as a reminder, we'll do the trust one September, right?
That's estate planning, right?
Yes.
We have estate planning in September, and then in October, we're doing, let me see, probate again.
Mhm.
And then in November, I have you scheduled for, let me see, where it is. Oh, maybe I don't have you in November.
So Monica asked if you can take the deed to City Hall yourselves. They're recorded at the recorder's office. From what I know, the recorder's office, I think, is closed to the public. I know, title companies can do their recordings. My office, we've been mailing in our deeds. I don't know if the recorder's office is currently open to the public. You would have to look into that. So we mail them in. Richard, double checking, so the look back does not affect a revocable trust? No. The look back rule that Richard is referring to is that if someone transferred a property within 3 years of their passing, they gifted it to someone or they created an irrevocable trust, Medi-Cal would go after that property because they would deem it a fraudulent transfer. Now, if you create a revocable trust, Medi-Cal will not seek to recover. All right, so I think that's it. Do you have any person in your office that can speak Chinese? Unfortunately, no. They can bring a translator if they wish. Okay, so I think that's it now. So I'm gonna exit the meeting, but it was nice. You're welcome, Monica, spending this morning with everyone else. Thank you.
Bye. Thank
Bye,
you.
I'll see you. You're welcome.